My name is Marion Cole, and for 31 years I have lived on the same 160 acres my grandfather cleared with a mule team back in 1952. Cole Ranch sits at the end of a gravel road that winds through cottonwoods and past a creek that never quite dries up, even in the worst of August. I raise cattle, I grow hay, and until 18 months ago, I thought I understood exactly where my land ended and everyone else's began. I was wrong about one very important thing. This is the story of how a homeowners association tried to build 12 houses next to my ranch without asking me a single question, and how they found out, in the worst possible way, that the only road leading to that land ran directly through property that had belonged to my family for 3 generations. Let me start at the beginning, because the beginning matters. My grandfather, Walter Cole, bought this land in 1952 from a rancher who was retiring and moving to town. Back then, the parcel he purchased included not just the ranch house and the pastures, but a long gravel road that connected the property to the county highway. That road wasn't an afterthought. My grandfather built it himself, with a borrowed grader and more sweat than I can imagine, because without it, the ranch was landlocked. Nothing could get in or out, not cattle trucks, not hay wagons, not an ambulance in an emergency. When my grandfather passed the ranch down to my father, and my father eventually passed it to me, the road came with it. It was recorded on the deed as Cole Lane, a private road, entirely within the boundaries of our property. For decades, nobody cared about this fact because nobody needed to. The land beyond our northern fence line was scrubby, unused range that belonged to a distant land trust, and as far as anyone in the county was concerned, it was going to stay that way forever. Then, about 2 years ago, a development company called Ridgeview Partners purchased that scrubby range from a land trust. And roughly 6 months after that, I started seeing surveying stakes along my fence line. I want to be honest with you. My first reaction wasn't alarm. It was mild curiosity. Land changes hands out here more than people think, and I assumed someone was doing some kind of soil study or environmental assessment. I didn't think much of it until a woman named Deborah Whitfield knocked on my front door on a Tuesday afternoon in March, holding a clipboard and wearing a blazer that had clearly never touched ranch dust before. She introduced herself as the president of the newly formed Ridgeview Meadows Homeowners Association. I remember blinking at her, because as far as I knew, there was no neighborhood there yet. There were no homes. There was nothing but sagebrush and jackrabbits. We are in the planning phase, she told me, smiling in that particular way people smile when they've already decided how a conversation is going to go. 12 custom homes, gorgeous lots, mountain views. We wanted to be good neighbors and let you know construction will likely begin within the year. I thanked her for the courtesy and asked, out of genuine curiosity, how they planned on getting construction equipment to the site. The land trust property, as far as I knew, had no direct access to any public road. The nearest county highway was almost 2 miles away, on the other side of my ranch. Deborah's smile flickered, just slightly, and she said something vague about access solutions being finalized by our engineering team. Then she handed me a glossy brochure with a rendering of 12 beautiful homes nestled among trees that did not currently exist on that barren stretch of land, thanked me for my time, and left. I want to tell you I immediately suspected what was coming. I didn't. I filed the brochure in a drawer and went back to fixing a water trough that had been leaking for a week. It wasn't until almost 2 months later that I understood exactly what access solutions meant. That understanding came in the form of a certified letter. The letter was from a law firm representing Ridgeview Partners, and it informed me, in very polite but very firm language, that the developer intended to establish what they called a necessity easement across a portion of my property, specifically, along Cole Lane, the private road my grandfather built by hand 70 years ago. The letter explained that because the Ridgeview Meadows parcel had no other viable access to a public roadway, state law provided a legal pathway for landlocked property owners to obtain access across a neighboring parcel, provided fair compensation was offered. I sat at my kitchen table and read that letter 4 times. Now, I want to pause here and explain something, because this is where a lot of people get confused about easement law, and frankly, so was I until I spent a great deal of time and money learning the details. It is true that in many states, if a piece of land is truly landlocked, meaning it has no access to a public road whatsoever, the owner can sometimes petition a court for what's called an easement by necessity across a neighboring property. This exists so that land isn't rendered permanently useless. It's a real legal doctrine, and in some circumstances, it's a fair one. But it isn't automatic, and it isn't unconditional. And it certainly isn't something a private developer can simply declare and then proceed to build a road through your property before any court has ruled on the matter. That, however, appeared to be exactly what Ridgeview Partners intended to do. I called an attorney the next morning. Her name was Patricia Alvarez, and she had handled a boundary dispute for a neighboring rancher a few years back, so I trusted her judgment. I drove the letter to her office that same afternoon. Patricia read it carefully, then read it again, and then looked up at me with an expression I would come to recognize very well over the following months, the look of a lawyer who has just spotted something the other side clearly hoped nobody would notice. "Marianne," she said, "before we talk about easements, I want to know something. Has anyone from Ridgeview Partners or this HOA actually surveyed your deed history?" I told her I didn't know. Patricia spent the next 2 weeks pulling records from the county recorder's office, deed histories going back to the original 1952 purchase, water rights filings, old plat maps, and even some handwritten notes my grandfather had kept in a metal box that my father had passed down to me without ever fully explaining their significance. What she found changed everything. Cole Lane was not simply a road that happened to run across my property. It was a private easement-free roadway, fully owned in fee simple by my family, built entirely with private funds, and, this was the critical part, it had never, at any point in 70 years, been dedicated to public use, nor had any prior owner of the land trust parcel ever established a legal right to use it. In other words, the land Ridgeview Partners had purchased had never had access rights across my property. It had simply been landlocked and undeveloped for so long that nobody had ever needed to test the question. More importantly, Patricia discovered something in the original 1952 deed language that the developer's legal team had apparently either missed or chosen to ignore, a specific clause, written by the original seller and preserved through every subsequent transfer, stating that the roadway was reserved exclusively for the use, benefit, and enjoyment of the Cole family and their successors, and explicitly excluded from any future access grant to adjoining or nearby parcels absent written consent of the Cole family landowner. In plain English, my grandfather, whether he fully understood the future implications or not, had made absolutely sure that nobody could ever force a road through his land without my family's permission. Patricia sat back in her chair after explaining all this and said, "They are going to need your consent, Marianne. Real consent. Not a certified letter telling you what's going to happen. And if they try to build without it, we can stop them cold." I won't pretend I wasn't relieved. But I also want to be honest that relief was mixed with a strange kind of anger, because it was becoming clear that Ridgeview Partners had known, or should have known, about the access problem before they ever purchased that land. 12 custom homes with mountain views don't get built on a whim. There would have been feasibility studies, title searches, environmental assessments. Someone, somewhere in that process, had almost certainly seen the access issue and decided to gamble that a rancher in her 60s wouldn't fight back. They gambled wrong. Over the next several weeks, the situation escalated in ways I genuinely did not expect. It started with another visit from Deborah Whitfield, this time accompanied by 2 men in suits who introduced themselves as representatives of Ridgeview Partners' development team. They sat in my living room, sipped the coffee I made out of old habit and manners rather than hospitality, and laid out what they called a generous offer. They offered me $40,000 for a permanent easement across Cole Lane, allowing unrestricted construction and resident traffic through my property, indefinitely. I asked Patricia later that day what $40,000 actually represented in terms of what they stood to gain. She laughed, not a happy laugh, and told me that 12 custom homes with mountain views, in that market, at that time, were expected to sell for well over $800,000 each. The land alone, once it had legal access, would be worth millions more than it was worth landlocked. $40,000 wasn't a generous offer. It was an insult dressed up in a smile. I declined. Deborah's demeanor changed noticeably after that meeting. The politeness didn't disappear entirely, but it thinned out, the way ice thins before it cracks. Within a month, I began receiving a stream of letters, first from the HOA's attorneys, then increasingly from Deborah herself, no longer on official letterhead but in personal emails that grew progressively less patient. She wrote about how 12 families were counting on their dream homes. She wrote about community growth and property values and how my stubbornness was standing in the way of progress. One email, which I saved and later shared with Patricia, went so far as to suggest that if I didn't cooperate, the HOA's legal team would find another way, and that I would regret making this harder than it needed to be. I remember sitting on my porch that evening, watching the sun go down over pastures my grandfather had cleared by hand, and feeling something settle in me that wasn't fear. It was resolve. During those weeks of escalating letters, I want to describe something that doesn't often make it into stories like this, and that's the sheer exhaustion of simply running a working ranch while also fighting a legal battle. Cattle don't care about certified letters. Hay doesn't wait for court dates. I was up before dawn most mornings checking fence lines and feeding stock, and then spending my afternoons on the phone with Patricia's office, or driving 40 minutes into town to sign affidavits and gather old records from the county archive. There were nights I fell asleep at my kitchen table with a folder of deed history still open in front of me, the porch light left on, my old dog Biscuit curled up under the table waiting for me to finally go to bed. I mention this because I think people sometimes imagine these fights as dramatic courtroom showdowns, all fireworks and clever speeches. Mostly, it was paperwork and patience and the low hum of worry that sits behind your ribs when you don't know if the life you've built is actually as secure as you always assumed it was. During this period, I also had a conversation I still think about often, with my neighbor to the west, a rancher named Tom Okafor who had run cattle on his own place for almost as long as I had run mine. Tom drove over one evening, unannounced, with a six-pack of root beer and a folding chair, and sat with me on the porch for a couple of hours without saying much of anything useful about the legal situation. Mostly he just listened. Near the end of the evening, he told me something his own father used to say, that land doesn't defend itself, people do, and that the paperwork only matters if somebody's willing to stand behind it. It wasn't legal advice, but it was exactly the kind of thing I needed to hear that particular week, and I've never forgotten it. There was also a moment, about 6 weeks into the dispute, when the HOA attempted something I hadn't anticipated. Rather than approaching me directly again, Deborah Whitfield organized a community outreach meeting at the county fairgrounds, inviting local residents to hear about their exciting Ridgeview Meadows development and, as I later learned from a friend who attended, subtly framing the access dispute as an unreasonable holdout by a single landowner blocking growth and opportunity for the whole area. I wasn't invited, which told me plenty about the intent behind the meeting. A few attendees who knew me personally pushed back on the framing right there in the room, apparently, and asked pointed questions about why the developer hadn't simply reached a fair agreement with a long-time local family instead of trying to build public pressure against her. Deborah reportedly grew visibly frustrated and cut the question and answer portion of the meeting short. I only found out about that meeting well after the fact, and honestly, it clarified something for me. This had never really been about a road. It was about whether a company with money and lawyers could simply outmaneuver an individual landowner by controlling the narrative and hoping she'd feel isolated enough to give in. I decided, sitting on my porch that night with Biscuit's head on my boot, that I wasn't going to give them that. Ridgeview Partners' next move was to attempt exactly what Patricia had warned they might try. Without my consent, without a court order, and without so much as a phone call, a survey crew showed up early one morning with flags, stakes, and heavy equipment, and began preparing to grade a section of Cole Lane where it crossed into the disputed portion near my northern gate. I drove out there myself, in my truck, in my work boots, and I asked the crew foreman, as calmly as I could manage, who had authorized them to be on my land. He seemed genuinely confused. He told me his company had a contract with Ridgeview Partners to prepare a construction access road, and that as far as he understood, the paperwork was all sorted out. I told him it was not sorted out, that this was private property, and that if his equipment crossed onto Cole Lane without my written permission, I would be calling the county sheriff and pursuing a criminal trespass complaint in addition to the civil case my attorney was already preparing. To his credit, the foreman stopped his crew immediately and made a phone call. Within an hour, his equipment was packed up and gone. But the message from Ridgeview Partners was now unmistakably clear. They intended to build first and settle disputes later, betting that once construction had begun, courts and public opinion would be more inclined to let it continue rather than unwind an active project. Patricia filed for an emergency injunction the very next day, and within a week, a judge granted a temporary restraining order preventing Ridgeview Partners or any of its contractors from entering, grading, or otherwise altering any portion of Cole Lane pending a full hearing on the matter. That hearing, when it finally happened 3 months later, was one of the more remarkable days of my life. Ridgeview Partners' legal team argued exactly what I had expected, that their client's 12-lot development was landlocked, that state necessity easement law entitled them to reasonable access across the only viable route, and that my refusal to negotiate in good faith was obstructing a legitimate and beneficial development for the county. Patricia's response was methodical and, frankly, beautiful to watch. She walked the judge through the 1952 deed, sentence by sentence. She presented the original reservation clause, preserved unchanged through every subsequent deed transfer for 70 years. She brought forward a real estate title expert who testified that any competent title search performed before the Ridgeview Partners land purchase would have revealed this restriction clearly, meaning the developer had either failed to conduct proper due diligence or had proceeded despite knowing the risk. Then she made the argument that, I believe, ultimately decided the case. She pointed out that the doctrine of necessity easement exists to prevent land from becoming permanently useless through no fault of its own owner, typically in situations where a parcel becomes landlocked because of how it was subdivided from a larger tract. But Ridgeview Partners' land had not become landlocked through any accident of history. The company had knowingly purchased already landlocked property, fully aware, or reasonably should have been aware, that no legal access existed, in the apparent hope that either I would sell my consent cheaply or that a court would bail them out after the fact. I remember sitting in that courtroom, in a blazer I'd borrowed from Patricia's paralegal because I didn't own anything that felt appropriate for a hearing like this, watching the developer's lead attorney, a sharply dressed man named Bradford Kessler, lay out his argument with the kind of practiced confidence that comes from winning a lot of cases against people who couldn't afford to fight back properly. He spoke about regional housing shortages, about the economic benefit of new construction, about how courts across the state had, in various circumstances, granted necessity easements in the interest of not letting land sit idle and unusable. He wasn't wrong about the general law. He was simply hoping the judge wouldn't look closely enough at the specific facts of our case to notice the difference. Patricia, when her turn came, didn't raise her voice once. She laid the original 1952 deed on the exhibit table, along with copies of every subsequent transfer, each one showing the same reservation clause carried forward unchanged, generation after generation. She called an appraiser who testified about property values in the area, making clear just how much financial upside Ridgeview Partners stood to gain from access that had, until that point, cost them nothing beyond a single certified letter and a lowball offer. And she called me to testify, briefly, about my grandfather, about the mule team, about the hours he spent grading that road by hand so a bad winter storm would never strand a sick calf or an ambulance 2 miles from the highway. I hadn't planned on getting emotional on the stand, but I did, just for a moment, talking about my grandfather. I looked up afterward and saw Judge Voss watching me with an expression I couldn't quite read, somewhere between patience and something gentler. I don't know if that moment changed his mind. Patricia told me afterward that judges rule on the law, not on sentiment, and she's probably right. But I also think a courtroom is still a room full of people, and sometimes the truth of a thing lands even when it isn't strictly part of the legal argument. The judge, a soft-spoken man named Judge Ellery Voss who had clearly seen his share of land disputes over a long career, took nearly 6 weeks to issue his written ruling. When it finally came, it was unambiguous. The court found that Ridgeview Partners had failed to establish the legal prerequisites for a necessity easement, specifically because the landlocked condition of their property was neither accidental nor unforeseeable, but rather a known and assumed risk at the time of purchase. The court further found that the 1952 deed reservation clause was valid, enforceable, and controlling, and that no construction, grading, or access activity of any kind could occur across Cole Lane without the express written consent of the Cole family. In effect, the judge ruled that Ridgeview Partners had bought worthless, landlocked property, and it was not my responsibility, nor my obligation, to bail them out of a bad business decision. I would love to tell you the story ended there, with a tidy legal victory and nothing left to say. But real life rarely wraps up so cleanly, and the aftermath of that ruling turned out to be almost as interesting as the fight itself. Word of the ruling spread through the county fairly quickly, as these things do in a place where everyone knows everyone else's business within about a week. Some of my neighbors were quietly delighted, having grown tired of watching outside developers buy up rangeland and reshape the character of the valley without much regard for the people who'd lived there for generations. A few others were less sympathetic, arguing that new development brought new tax revenue and new opportunity, and that I was standing in the way of that for personal reasons. I understood both perspectives, even if I didn't agree with the second one. I had never been opposed to growth in general. I was opposed to a company trying to bully its way across my family's land without so much as a fair conversation, and then attempting to build before the legal questions were even settled. About 2 months after the ruling, I received a phone call I genuinely didn't expect. It was from a man named Harold Ridgeview himself, the founder of Ridgeview Partners, who as it turned out had not been directly involved in the earlier negotiations and had, according to him, only recently learned the full extent of how his development team and the HOA president had handled the situation. He asked if he could come speak with me directly, without lawyers present, just to talk. I was skeptical, but curiosity got the better of me, and I agreed to meet him at the ranch. He arrived alone, in jeans rather than a suit, and spent the first 10 minutes simply looking around the property, asking genuine questions about the cattle, the hay operation, and the history of the land. Eventually, he got to the point. He told me that after the court ruling, his company had done a hard internal review of the entire Ridgeview Meadows project, and that what they found troubled him. The original feasibility study, commissioned before the land purchase, had in fact flagged the access restriction clearly. That report had been buried, either through negligence or, as one internal email suggested, a deliberate decision by a since-departed executive who believed the issue could be resolved through negotiation or legal pressure after the fact. Harold Ridgeview told me, somewhat to my surprise, that he wanted to make it right, not because a court forced him to, since the ruling had already settled the legal question, but because he didn't want his company's name attached to what had essentially become a story about bullying a longtime rancher out of her family's land. He offered a new proposal, one that Patricia and I spent several weeks reviewing carefully before I agreed to any of it. Rather than a one-time easement payment, Ridgeview Partners offered a substantial, ongoing access agreement, a permanent right-of-way I retained full ownership and control over, with an upfront payment more than 10 times the original offer, plus an annual maintenance fee paid to me for the upkeep of Coal Lane, since increased traffic from 12 new homes would obviously put more wear on a road my family alone had maintained for 70 years. The agreement also included a clause guaranteeing that any future expansion or additional development relying on that same access would require renewed negotiation and consent, not an assumption of open-ended use. I want to be clear that I did not do this because I suddenly warmed to the idea of a subdivision next door. I did it because it was, finally, a fair deal, offered honestly, with my rights as the landowner respected rather than steamrolled. The homes have since been built. I see the headlights of new neighbors passing along the edge of my property some evenings, and I won't pretend it doesn't feel different than the quiet, empty range that used to sit beyond my northern fence. But it feels different in a way I can live with, because it happened on terms I agreed to, not terms forced upon me. As for Deborah Whitfield, she resigned as HOA president not long after the ruling came down, reportedly under pressure from Ridgeview Partners leadership once the internal review revealed how aggressively she had pushed the construction crew to proceed without proper authorization. I don't know her personally beyond those handful of encounters, and I try not to hold on to more anger than is useful. But I won't forget the tone of those late emails, the assumption that an older woman running a cattle ranch alone would simply fold under pressure rather than fight for what was legally and rightfully hers. Looking back on the whole ordeal now, more than a year removed from that first knock on my door, I keep returning to one particular thought. My grandfather built that road by hand, with a borrowed grader and no guarantee that anyone in the future would understand why he insisted on that strange little clause in the deed, the one reserving the road exclusively for Cole family use. He couldn't have known, in 1952, that 70 years later, a development company would try to drive bulldozers across his life's work without asking. But he protected it anyway, because that's what people who build something with their own hands tend to do. They protect it, thoroughly and deliberately, for people they'll never meet.